Uh, are we ready? Okay, good. Good afternoon, everybody. Is that Mr. Becker?
Yes, good afternoon, everybody. Good afternoon, Mr. Chair.
Good afternoon, Mr. Becker. Yeah, so we have been communicating via emails, and now I have the pleasure of meeting with you.
Likewise, Mr. Chair.
Yes. I suppose, as a brief indication, the whole purpose of today was at my instance because I wanted to provide an opportunity to people who may have been mentioned to their detriment in particular, and to provide a platform for them to respond to those allegations. Now, in the course of this past week especially, it was indicated to me that certain persons or certain representatives of persons about whom allegations have been made would like to have more time to engage the allegations themselves and or to respond, and even if it meant, pointing out that even if they do not rebut the allegations that are made, they nonetheless would like to put some interpretation of the events, the nature of which would clarify to the Office of the Transformation Ombudsman where they would be coming from. Now, I then felt that it was appropriate that we should, even though we have strictures of time, in terms of the timeline that we were given within which to complete this SJN project, my sense was that if people need time, then they must get time on good cause shown, because what is important is not so much to see what legal points one can take, but simply to provide a platform for dealing with the allegations procedurally fairly, as well as, substantively fairly. So today, I want to hear you, Mr. Becker, and hear the evidence leaders to the extent that it might be necessary. I see that there is a communication that was sent to Mr. S. July. It has just been put in front of my face. And there is, I'm told, a formal application signed by your good self, 21 paragraphs in which the heading of which is extension of period within which responses to allegations made during SJN hearings may be submitted. I would then assume that that constitutes a basis for you to talk to me in this informal process. You are welcome then, David, to make your submission or to talk to what you would really want to see happening.
Thank you. Thank you, Mr. Chair. Firstly, thank you for the opportunity to address you all today. I appreciate that opportunity. Secondly, how would you like to be addressed, Advocate Ntsebeza, Mr. Chair or Mr. Ombudsman? Do you have any particular preference? I want to make sure I use the right terminology, yeah?
No, I have no, except that it's Ntsebeza, not Nsebenza.
Okay, Ntsebeza. Thank you.
But if it assists you, you will be surprised how many African people will call me Nsebenza because they want me to Sebenza. And they say, I'm not working, man, I'm whispering.
Okay, well, if you don't mind, I'll just simply call you Mr. Chairperson or
Mr. Chair. That will be sufficient.
Okay.
Yes.
And then just in respect of my submissions, for the sake of clarity, yes, what you should have in front of you is a formal written submission, which is just a couple of pages long. And then attached to that is an annexure, which is my letter, I think, of the 12th of August.
Yes.
That's one of the annexures. So you'll note that I did write a letter on the 12th requesting, and I emphasize the word requesting, an extension. And then subsequently, I then wrote a formal submission. I think that was on Thursday last week.
Yes.
And yes, I should perhaps start by emphasizing that I'm well aware, having worked on inquiries and investigations, that things inevitably take more time than they should. And they become more complex. So I am sympathetic to the Ombudsman's office in that respect, because, you don't always foresee how long and complicated and administratively, challenging things might become. So, it's yes, there may have been, delays in getting transcripts, et cetera, but, it's nobody's fault. It just is what it is.
Yes.
I'm sympathetic from that point of view, because these things develop sometimes in ways that we can't imagine. And I'm not here to cast blame. I simply want to make submissions and to try and hopefully, come to an agreement in terms of what is reasonable in terms of the process. So, I'm not a litigating attorney, Mr. Chair. I'm actually a commercial lawyer. So I'm a collaborative lawyer. I'm not used to making antagonistic submissions in a formal court proceedings. So I'm here to make my submissions, and that was the purpose really of the engagement with Mr. July the previous Friday, and it was a very constructive engagement, which I've emphasized in my submission, was to try and come to some sort of sensible arrangement as regards to the rebuttal submissions.
Yes.
So yeah, with that, perhaps I'll just touch upon a few of my submissions. I don't intend to go through it in a huge amount of detail.
Yes.
But if you wouldn't mind, just touching upon a couple of the submissions, and paragraph 3 perhaps would be the most appropriate place to start in terms of my submissions. The submission really there, Mr. Chair, is that the complainants were given 24 days to make submissions from the time that they were invited to do so. And in some cases, some of the complainants were given over 2 months to provide their signed affidavits. Now, I understand, Mr. July's point that, yes, perhaps some of their statements weren't in the correct form, or they had to go back and resubmit in appropriate form. But the fact of the matter is that they were given at least 24 days, and in some case over 2 months to submit, to make their formal written signed affidavits. And so I think that's an important principle to bear in mind when Ombudsman considers the issue of procedural fairness. Yeah. Now, I'm not saying that an identical period of time should be given to the respondents. I accept that that may not necessarily be the case in order to be procedurally fair. Yeah. However, I do think that that should be taken into account. And therefore, when I submit later in my submission about what an appropriate period of time might be, I'm guided by that 24-day period that was given to the complainants. So, and I think that's an important principle. In paragraph 4, Mr. Ombudsman, I turned to the announcement on the 5th of August, which I was unable to verify, but which I read about on News 24. I didn't receive any personal notification to this extent, but I accepted the fact, having read it in the media, that on the 5th of August, people were given until the 18th of August. That was the official date for a response. So when I say I was slightly surprised by that, it was in the context of paragraph 5 of my submission that I was surprised, because on that date, on the 5th of August, when I saw that, I was slightly taken aback, because I thought, well, if we have to reply in 13 days' time on the 18th of August, by that stage, I had still not received a full set of transcripts and indeed a full set of affidavits. I'd received some, and some of which were unsigned. Leading to paragraph 6 of my submission, Mr. Chair, it was then, by the 12th of August, I was starting to become a bit alarmed, because that was now 6 days before the dreaded date of the 18th of August. I had only received one transcript, and that was of Dr. Eugenia. And subsequently, after the meeting, or I think on the same day of the meeting with Mr. July, on the 13th of August, we then received the bulk of the transcripts. Later transcripts were received by from Mr. Moreau and Mr. Manak on the 14th and 18th of August. So now I accept the point that Mr. July has made, that there's nowhere in the terms of reference does it say that transcripts have to be provided. However, I do think it's extremely sensible of the OTO to have provided transcripts. And I say that because it's not always been possible to follow the proceedings. And Mr. July makes the point, yes, I said that I would be trying to follow the proceedings or following them, but these proceedings have gone on for some time, and I'm sure you'll appreciate, I've got much like a doctor or a dentist, I've got to practice both in South Africa and the UK, and I need to make myself available to my clients. So I've not been able to follow day to day the proceedings. And I don't think it's necessarily reasonable of Mr. Smith to have followed the day-to-day proceedings, because he's got a job as director of cricket. In fact, he's also taken on the commercial, the commercial role as well within Cricket South Africa. Excuse me. Sorry. So I think it's difficult to have followed the day-to-day proceedings. I think those transcripts are very useful, and that in that regard, I think it was a sensible decision on behalf of the OTO. And on the 15th of July, I had some correspondence with Mr. Tom, who I think is sitting there with you, and he said, I will establish with CSA how soon the transcripts of the testimonies will be may be made available. So there was an expectation that transcripts would be given. And like I said, I think that is sensible, because in some cases we were not able to follow on a day-to-day basis. And also, Mr. Ombudsman, the oral evidence, of course, very often differed from the written evidence in almost every case. So I think respondents should be, in being given an opportunity to respond, in principle, I think they should be given an opportunity to respond not only to the written statements, but also to the transcripts. because that way they can then fully know what the allegations are against them, and they can fully comprehend those allegations and respond to them accordingly. Now, the point about the written statements, and I go into detail in my submission on what was given to us when, and some statements were given to us in August, a few days before that 18 August deadline. The concern I have about the unsigned statements, because some of them were unsigned. For example, Tami Tolakile's 19th of July submission was unsigned. I think his 5th of July submission was also unsigned. And Mr. Lonwabo Tatobi's affidavit of the 15th of July also seems to be unsigned. And the point I'd like to make there, Mr. Ombudsman, is that I'm just concerned that there's not some other version, some other signed version that's floating around. When you received an unsigned version, you sometimes think, well, is this the final version? And so the concern there was, is there now some other version that's signed that's now sitting around that I don't have? So the principle, I think, if we stick to just principles for a moment, my submission is that a respondent should be given a fair amount of time to reply, a fair amount, and we can talk about what a fair amount is, once they've received the written signed submissions, signed affidavit, and a transcript. And when I talk about the signed affidavits, I'm including annexes to those affidavits, because again, I think in fairness, it's entitled to see what the annexes were to that affidavit. I think that stands to reason. So hence my request, in view of the delays in getting that information, the request for an extension was then made on the 12th of August by me in my letter. And I do want to emphasize again that was a request. I think if you've read the letter, Mr. Ombudsman, you'll plainly see that I make no demands in that letter of the 12th. And I would like to make that point. I start in the letter by referring to the fact that I'm making a request. In the second paragraph, I talk about requesting additional time, and in the final paragraph, I talk about based on the reasons provided, we sincerely hope the OTO will look favorably upon our request. So I do want to just again emphasize, because I think there was a misunderstanding that perhaps you thought I was making demands on the office of the OTO, and that's certainly not the case. I think the correspondence bears that out. So turning back to my submissions, in paragraphs 6 and 7, I talk about when we received these statements and the principle of being able to respond once we know what those allegations are. So in the spirit of sort of procedural fairness and audi outram partem, with the complainants having been given 24 days, the way I approached this, Mr. Ombudsman, was to think, well, perhaps the respondent should be given a period of 3 weeks. I think that would be suitable. Once the time they've received the signed affidavits with the annexes together with the relevant transcripts. So that's kind of how I approached it in terms of what I thought would be procedurally fair. I'm obviously well aware of the fact that the Office of the Ombudsman is under time constraints, and I allude to that in my submission. And should the, and I mentioned this in the meeting with Mr. July, I think that the Ombudsman shouldn't be under undue time pressure to deliver his report. And I don't think it should be rushed. In fact, I don't think any of these proceedings should be rushed, because we're dealing with very important matters here. And they're very significant, some of the allegations that have been made. And I can talk specifically about the allegations against Mr. Smith, my client. These are very far-reaching allegations that have been made against him that could and will no doubt affect the rest of his career. Similarly with me, there have been some very far-reaching allegations made against me. I'm a practicing attorney of some 25 years, and I've never had these types of allegations made against me. They are very significant, and therefore, people like myself, Mr. Smith, anybody, in fact, who is a respondent in these proceedings, should be given a fair opportunity to reply. And similarly, the Ombudsman should be given a suitable period of time in which to hear these submissions, number one, and number two, finalize his report. And, that's obviously for the Ombudsman to take up with CSA. And I mentioned it, in my meeting with Mr. July, because for me, that's fundamental. Yeah, these allegations are serious. And, yes, they can't go on forever, but everybody needs to be given a proper opportunity to make submissions and a proper opportunity to reply. And similarly, the Ombudsman needs to be given a proper opportunity to file his report. None of these parties should be rushed in this process because these are very important proceedings. So I just wanted to emphasize that point. Then we come to the meeting with Mr. July on the 13th of August, and I'm not going to dwell on that. We obviously have a dispute in terms of exactly what was said at that meeting and the expectations which arose from that. Mr. July has a particular view on that. The three of us have a different view. We all clearly felt that there had been an agreement at that meeting, so much so that we went away and told our various constituents. Mr. July is concerned that I told certain people, and let me explain that for a second. Following that meeting, it had been, it was clear in our minds certainly that the proceedings would open again for oral submissions on the 6th of September. And we discussed why we felt that was appropriate. And Mr. July, I don't think he disagreed with us, that he thought that was an appropriate timeline, which I think is an important point to make today. And it was a very positive, very constructive discussion, and I welcome the approach which Mr. July took in that meeting, because he opened it up by saying, I want to try and come to some sort of reasonable consensus here on what is, what would be appropriate in the circumstances. And we, nobody made any demands, nobody attacked anybody. It was a very constructive, professional discussion, and we all came to the conclusion that that would be an appropriate timeline, we felt, and I still feel that's an appropriate timeline, to be fair. And then off the back of that, I then phoned my partner who's working with me on this matter and informed him. I phoned Mr. Louis Cole because I've been talking to him on a day-to-day basis about his submissions and my submissions in relation to the match fixing. I phoned Mr. Smith and let him know. Mr. Jacques Fall contacted me over the weekend because he wants me to file a confirmatory affidavit in respect of his submission. And I informed him. I said to him, but hang on, he said, we've got to rush. We've now got to get these things in. And I said, well, hang on. I was in a meeting yesterday and it was discussed that you would only file your submissions the week of the 15th, potentially. So when Mr. July appears to question why I then relayed this information, it was relayed in good faith, I assure you. After the meeting on the Friday, the 13th, I relayed that information. And likewise, when A.B. de Villiers' agent contacted me about when a submission should be made, I relayed that to him. So it was made in good faith. Now, I don't think it serves us today to dwell too much on that meeting of the 13th with Mr. July. We have a slight difference of views on that meeting. I don't think it serves us today to dwell too much on that. I would rather focus on what I believe is a fair process going forward in terms of when the respondents should file their rebuttals. I think that's a more constructive approach. So I would only conclude, Mr. Ombudsman, by saying, reiterating that I think a period of 3 weeks from the time of receipt of signed affidavits and transcripts, what I mean is a full set of signed affidavits and a full set of transcripts. For example, Mr. Smith still doesn't have the submission of Dr. Eugenia. I believe she made a written submission. Mr. Smith hasn't seen that, and he's being asked to respond to that. So I think that in principle is a fair solution, the period of 3 weeks. Having said that, I would go with the 6th of September in my personal view. That is my request to you, sir, as the Ombudsman, that we begin the proceedings again on the 6th with Mr. Cole, myself, Judge Ngwepe, ready to file our submissions by the 6th and to come and give what we believe is very important oral submissions in this case of that particular week. That would be my humble request to you, sir. I think that that's reasonable and appropriate in the light of some of the administrative delays, which, as I say, they happen. I've been in positions, like I said, where I've been involved in similar investigations, and inevitably these things do take longer, especially when you're dealing with matters of this importance. So, Mr. Ombudsman, that is my submission, and I pray that you look favorably on our request for that extension, and I look forward to your response on this and to addressing you both through full written affidavits. I can assure you they will be very comprehensive, because comprehensive is the term used in the terms of reference, and we're dealing with important matters here. So I can assure you that the response will be comprehensive. I'm very mindful of the fact that the Ombudsman is entitled to make findings in this matter, which means that each and every allegation has to be addressed, and we are taking time to address each and every single allegation, not just Mr. Smith, but myself as well. And I look forward to making those submissions to you in due course.
Yeah. Is it Mr. Tom?
Thank you, Mr. Chair. Is it on? Okay. Hi, Mr. Becker.
Hello there.
Yes.
Please call me David if you wish. I have no problem with that.
All right, Mr. Becker. Thank you. I will call you David going forward. Mr. Chair.
Maybe. Oh, okay. All right.
Okay.
Perhaps just about the date. Do you have any problem with the date? Never mind that it's a, it's a date that is going to negatively impact on my timeline. But I take into account the submissions that Mr. Becker has made about this thing not having to be dealt with in terms of the report having to be in by the end of September. It must be dealt with in terms of whether or not parties on both sides have been given sufficient opportunity to engage the allegations.
Mr. Chair, I was part of that meeting, and I can tell you, Mr. Chair, I don't have any objection to the date that was requested, that has been asked for by Mr. Becker. He did ask for that date even during that meeting. You might not recall, I was very quiet in that meeting. I did not utter a single word. So Mr. Chair, on that front, we don't have an issue with the request for time to submit by the 6th. But Mr. Chair, if you would allow me, Mr. Chair, I think I've, as Mr. Becker has indicated in his presentation to you, I think that I have dealt with Mr. Becker in relation to the submissions which have been made by the parties, particularly in relation the ones pertaining to the match fixing investigation. I believe that I was one of the people or the professionals in the Worksman's team that were interacting with Mr. Becker. And I can tell you, Mr. Chair, that the contents of Mr. Becker's letter dated 12 August 2021 came as a surprise, Mr. Chair, to us as Worksmen. Not because Mr. Becker was not entitled to raise the issues that he has raised in that letter, but because, Mr. Chair, I'd been interacting with Mr. Becker, and our interactions with Mr. Becker, even at the point where I indicated to him that we would be providing him with transcripts as soon as they have been made available to us, I had expected, Mr. Chair, at the very least, to the extent that Mr. Becker does not have attachments, by way of example, and I recall that the one problematic attachment is an attachment in respect of Mr. Peterson's affidavit. And Mr. Chair, we do say in our response that to date we've not been able to secure that attachment, and we will endeavor to provide that attachment to Mr. Becker, and we want to, as evidence leaders in the Secretariat, want to assure him that we will do our best endeavors to provide him with that. The second issue, Mr. Chair, that I want to just talk to, Mr. Chair, in respect of Mr. Becker's submission was his, I think it's paragraph, he has dealt with the issue of the informing other parties about the meeting that was had with Worksmans. I don't think that requires anything further than what is stated in the affidavit. Sorry, in Mr. July's response. Now, Mr. Chair, one thing I wanted to take with Mr. Becker and just gather from him, maybe, when he replies, maybe he will be able to explain it. Mr. Chair, at some point, you have made a very important statement, in my view, around the exigencies and the time constraints that we operate under, and Mr. Becker, I think he appreciates that. That we were too ambitious, Mr. Chair, when we started as the Secretariat, and we wrote to Mr. Becker, and we detailed to Mr. Becker the allegations made against his client, and Mr. Becker, politely indicated to us that, look, guys, I want the actual statements which have been filed by the parties. And we then said, all right, we will do so. And we've then further, in our further interactions with Mr. Becker, then that's how we've communicated with him. That's how we've sent notices to him. So we are a little bit surprised, Mr. Chair, to find Mr. Becker raising a concern around the manner in which he had been notified, that he's been notified by way of emails in circumstances where in the past or on one occasion he was given a letter which had the CSA letterhead, and it took him through the allegations. So, Mr. Chair, we just thought that it is important to because that issue is raised in the context of procedural fairness, to say that the process may not be fair in that regard because the evidence leaders have not been consistent in the way in which they've provided information to him. So, Mr. Chair, I just want to, in closing, Mr. Chair, I want to submit that we don't have an issue with that date that is requested by Mr. Becker. We're looking forward, Mr. Chair, let me put it at the outset. We're looking forward, Mr. Becker, to interacting with you insofar as any other document you think that has not been provided to you and you would want to have regard to it. Please, Mr. Becker, we would like to encourage you to interact with us in the same way you've been interacting with us in relation to the other, the match-fixing affidavits and the like. And then lastly, on the issue of the signing or otherwise of the affidavits, I can assure you, Mr. Becker, that the affidavits which were submitted to the chairperson and the SNJ hearings are exactly that. There will be, I can assure you that there will be no subsequent versions that will be floating up in the air, which differ from what you've been or anybody has been provided in so far by the evidence leaders. And I think, Mr. Becker, you appreciate that we're working remotely. It's not easy and some of these complainants are not even in Johannesburg. So it's not easy to then secure these signed affidavits, so I would like you to just take comfort in the fact that we've submitted those affidavits and they are what they are, and they are not about to change after the testimonies. Thank you, Mr. Chair.
Mr. Becker? Short reply?
Thank you, Mr. Chair. Mr. Tom, thank you for those comments. I certainly accept your point, or I take note of it as regards paragraph 20 of my submission. And actually, I'm in agreement with you on the fact that it's probably not pragmatic or sensible to advise every single respondent of the specific allegations against them. I think I mentioned that in my meeting. It doesn't seem to be practical or pragmatic. So I raised the point more in the context of consistency, that's all. I'm not for a moment saying that my client or even myself have been prejudiced thereby. So it was a concern about consistency, that's all. And I don't think we need to take it any further. I take on board your point fully. I will later today engage with you further on any outstanding documents. I think for the rest, we seem to be on the same page as regards to a potential timeline. And to that extent, I'm grateful.
Mr. Becker, Mr. Britzke, is it Britzke?
Britzke.
Andrew, is he your client, or is he acting independently?
No, Mr. Ombudsman, Saka is not my client in this particular case.
Okay.
No, I'm probably eating into his time, so I probably should sign off. But yeah, I should make it clear that, I had understood that perhaps it was clear that I'm only acting for Mr. Smith in this matter. Mr. Cole, I have said previously on record that I'm advising him, but he doesn't need my advice, to be quite frank. He's being advised by CSA in his capacity as an employee. And then I'm obviously acting on my own behalf in respect of my own response.
Thank you very much.
Thank you, Mr. Chair.
Yes.
So, Mr. Chair, can we expect a decision from you, or can at some point, and how is the process from here on in?
Can you expect
a decision on the timeline? I mean, I'm assuming you're going to listen to everybody today and then make your decision.
You're going to get it now.
Sorry?
You are going to get it now. Now.
Oh, okay. Thank you.
You won't leave here without getting it. You see, I need that weekend between the 3rd and the 6th. So you want the 6th of September, which is a Monday. I want you to let me have whatever it is you're going to give me on the 6th, give me on the 3rd, so that I am the one who uses the weekend. So I am comfortable with the reasons that you have given, and I would simply encourage an ongoing interaction between you and the Secretariat workspace, so that certain issues can simply be dealt with on an interaction basis, rather than that, the Ombudsman will have to decide this one as well. I would rather the parties are ad idem about matters of procedure and the fairness thereof.
That makes sense. That makes sense, Mr. Ombudsman, and I was very mindful of your directive to go via Mr. July. That's all. So.
No. You did well. You did well. So.
Okay, Mr.
My ruling, therefore, is that do whatever you want to do whilst you are interacting when need arises with the Secretariat workspace, and the extension to the date of September is up to the 3rd of September. You are given that much time to do the necessary. End of business, 3rd of September, 2021.
Okay. Thank you, Mr. Ombudsman. I will deal with your officers later about the who's coming to speak when, etc. That following week.
Yes.
Because I realize I'm eating into Mr. Bretzke's time, so I'll sign off now.
Yeah. Okay. Yeah.
Thank you very much, Mr.
Yeah.
Ombudsman.
Thank you.
and
You're
very
welcome. You're
Thank you.
welcome,
Thank
Mr.
you. Thank
Becker.
you. Thank you.
All right. Oh, Mr. Bretzke. I don't see you, Mr. Bretzke. You are hiding behind.
Can you see me now?
Yes, now you are centered. Probably.
Thank you, Mr. Chair.
They didn't want me to see you. They are hiding you away in some corner. Yes.
We're safely ensconced behind the mountain in Cape Town, Mr. Chair.
Yes. I gather that you are aware of the purpose of today. I just want to get a sense from representations that would be made to me, both in writing, and I've seen your submission. I've just seen it dated the 18th of August 2021, and I suppose you want to, if needs be, you would want to talk to that. And if I guess well, what you want to say is that it would serve you better and the interests of administrative justice well if you were given an opportunity to submit your response on the 6th of September 2021. I think that's the summary of the submission. But you are free to talk to me and let me hear if I agree with you.
Thank you, Mr. Chair. And yes, you are correct. That is a good summation of where I'm going to. But thank you for the opportunity. I appreciate it. I know you have a busy schedule and you're going through all of these submissions today, so I appreciate the time. I would like to start by just saying that SACA, from the outset of the SJN project back in August, September last year, we've noted our support for this process. It's important for Cricket South Africa. It's important for SACA. And with that in mind, we've had an ongoing engagement with your office and that of Vaxmans on procedural matters as they've arisen since, I think, back in April. With respect to yourself and to Cricket South Africa, I would like to say that I think the deadline of end of September cannot be there to the extent that it inhibits fair procedure for everybody involved in this. That would undermine the very objective of the SJN process. And that's probably something that one would have to say to the Cricket South Africa board rather than your office, but I think it is important. It cannot inhibit what has to be fair process to everyone involved. It is the intention of SACA to provide a comprehensive response to the various statements and allegations that have come through and the narratives that have come through in the various submissions that you heard. And if we were to fail to do so, it would be disrespectful to this process. So ensuring that we treat it with the respect it deserves, we need to be able to respond comprehensively and properly to everything that's been said in these hearings, because that's what is required for you, I believe, to be able to do a proper job and with the wisdom of Solomon that you require to give your ultimate response to Cricket South Africa. We have engaged Waxmans formally over the last few weeks and requested copies of statements as well as transcripts to ensure that we're able to respond. And over the past 2 weeks, these have been coming forth on a piecemeal basis as and when they become available. I understand how transcripts work. They get completed by the service provider, etc., within their time. And we did forward a final request to Waxmans on the 18th last week for the remaining outstanding. Waxmans, thank you for your response that we received this morning, have said that we now have everything. I think we do. I think we just need clarity on one, and that's Dr. Eugenia Kula-Amayo. I don't think we have the whole statement of hers, but maybe between Mr. Wachipa and the Ombudsman Office, we can just clarify that point. I think that's the only one that is now outstanding. As you would all appreciate, I think a review of the statements and transcripts and drafting replies is a very time-consuming process. We've got to review what's been provided, and we've got to even do research on some of the issues that have been raised. The written statements have been amplified verbally by individuals during the testimony, and we haven't completed that entire process yet. You will appreciate the transcripts we've got are over 1,500 pages, and that relates to about 17 submissions that we believe require a response from us. So it isn't just a case of sitting down and writing something. It is comprehensive. I'll also add, and I mentioned it then in my submission, that the time frame to finalize a response has been a cause of concern for us in the SACA office for a while. It's caused us sleepless nights, because as the hearings have progressed, we've realized the extent of work that is required from us to do justice to this process in responding. And we did raise that issue with the Office of the Ombudsman on the 30th of July in correspondence from our Mr. Wachipa, where we basically noted at that stage we'd only received 5 written statements and obviously no transcripts at that point and no further statements. And we noted at that time we were concerned as the timeframes we were putting pressure on us, yet we had to provide this comprehensive response. So we've put it out there that we have this issue. And I suppose that's one of the reasons that led to Mr. July, who I think recognized that, having our meeting on the 13th of August, where along with Mr. Becker and Mr. Musaji of ENS, we had a very constructive discussion actually on the challenges we were all facing. And I won't go into detail on that meeting, but that's where we got the agreement on the 6th of September as a reasonable period in which we could be expected to reply, given the extent of work that we required. We believe, and I think it's probably been canvassed already by other submissions, the concept of fair process, aldi alteram pactum, having a proper opportunity to respond is critical to this process as well. And the idea of the 6, when it was asked of me what I thought a reasonable period would be, I put forward the 6 because I believe that was a fair enough period relative to what work was required for us to be able to respond properly. I do want to just put it on record relative to your communications, Mr. Chair. We never demanded that date. It was part of the discussion, and I think Mr. July agreed that would be a reasonable time. I subsequently did communicate that to the SACA Executive Committee, the Players Committee, because that is where I get my mandate from. So I informed them on that Friday the 13th that those were the timeframes we were looking at. In terms of me having to draft, me having to go back to the SACA Executive Committee, getting their sign-off on what I'm saying, on what we are communicating. So that is an important point for us in terms of the process that we believe should follow in terms of fairness. Just a final point from me. I think it's important to note that from SACA, we don't have a team of attorneys working on this. We don't have the resources to have advocates or attorneys working on this, despite what some people might think. We're doing this, I'm drafting it myself, with the assistance of my team who are going through transcripts to assist me. So, and we've had no attorney sitting in the hearings being able to give us guidance of where we effectively are referenced. The challenge for us is going through the transcripts, going through the statements, and looking at specific narratives that have come through, because in some cases there's duplication in the narratives between players or organizations, pulling those strands together and being able to give you a comprehensive narrative in response to that. And again, that is not a process that is quick. it's a process that is taking us time in going through those transcripts. So we're doing it in-house, and at the same time, we're doing our normal day-to-day business. And with those points put before you, Mr. Chair, I would ask that it be confirmed that the 6th of September is a fair date for us, which is effectively 2 weeks' time for us to be able to submit, and then later in that week to actually give our oral submission. And I would say further, I don't think we're going to be in a position to submit before that date, given where we are with the work that's required at the moment. So with that, I'll leave my submissions there. I'll just respond on 2 points in the reply that I received from the Waxmans. Just on clause 4 of the reply of Waxmans, they reference the 13th of August meeting in the reply to me and say the detail of this meeting has been explained in our response to Mr. Becker and CSA submissions. And they incorporate them here. And just for the record, I haven't seen that, so I don't know what was said there. I don't think it's material, but I just would like to place that there. And also the point 6 on the Waxman submission that they do not oppose SACA's request to file their submissions on or before the 6th, which I presume is in their own admission that is a reasonable period given the extent of work required from our side. On that point, Mr. Chair, I will rest, and thank you for the opportunity.
Yes. Is it Mr. July or is it me?
It's still me, Mr. Chair. It's still me. Yes, Mr. Chair. We've responded. We filed a submission regarding the SACA request for extension, and in our submission, we do say that we do not oppose or we do not have an issue with the request for extension filed by SACA, and we do explain that SACA has, as Mr. Britsky indicated earlier, that they have in the past indicated their commitment to the process, and they filed a submission to you to give you their take of what they think the terms of reference say, and in what way they can contribute to the SJN process, and what it is that they have done within their ranks to try and address issues covered by the terms of reference. So, Mr. Chair, their submission is quite clear. They tell you why they need the extension. We leave it up to you, Mr. Chair, whether or not you give them up until the 6th of September 2021.
Yeah, Mr. Preska, I am persuaded by what you have submitted as a reasonable basis for you to seek an extension of time within which to make a submission that would enable you to deal effectively with any allegations that may have been made in statements or in testimonies that have come before me up to this point. And I think all submissions that have been made to me, which is why I thought this exercise was important, about September, end of September being the time within which I should have written a report to submit to the board, have been well made, to say, whilst that might be the aim or the targeted date by those who were keen on a report to come out of this SJN project. The reality is that there needs to be a balance between slavishly following predetermined dates by which things should have happened and making sure that getting to that destination, even if it means altering that date, must be fair to all the parties who are affected. And I think you are highlighting in your communication of the 8th of August, a number of aspects that one must take into account about what has been alleged and the need for those allegations to be dealt with in some way, because this is a critical process that needs fairness to be afforded to those who are affected by what is being said. And I'm quite happy as an ombudsman to ensure that parties are not prejudiced by a desire to finish, even if in the process of getting to the finishing post would be strewn with a lot of injustice to parties who are adversely affected by allegations that have been made about them in the process of trying to find the end objective of what is contained in the terms of reference that guide my function as the ombudsman in this project. I will ask from you what I've been asking from others who have made similar representations, to accept my proposal that the date should be Friday, the 3rd of September, rather than Monday, the 6th of September, 2021. It is for the same reasons that I have indicated to the others, that I would love to look at whatever it is that you will be saying in the weekend between the 3rd and the 6th. So as far as, therefore, I am, or I may be conceived to make a ruling to the submissions that have been made by you and the Secretariat, it is merely to say you have up to and including the 3rd of September 2021 to make whatever submissions you feel need to be made. In the interim, you are free to interact with worksmen because they are the Secretariat, they are people who advise me, and but they are freely accessible to all those who are in this process with me in an endeavor to deal with this very, very important subject at this very, very important time. You will know that there are tours that are being planned, and they may be, and these hearings may be distractions to those who are players or selectors or even managers, given that there is a busy period of time, if I believe what I read in the newspapers. So whilst we have to hurry to get to the end, we must hurry slowly. So unless you say no, that is my offer, and I hope my desire to use the weekend does not disorganize your plans, which probably were for you to finalize also your submission during that weekend.
Thank you, Mr. Chair. I'm concerned about the volume of work you're going to have on the weekend of the 4th and the 5th, which is why I would really prefer to submit on the 6th. We had wanted to submit on the 6th because we believed that was a time frame where we could get our confirmatory affidavits in, etc. I respect your position of saying the 3rd. I can undertake to endeavour to get it to you by the 3rd. This is not a case of us saying, well, we want to submit when we submit. If I could finish the papers by the 2nd, I'd submit them to your office. It's endeavouring to get the papers completed as soon as I can and submit them to your office, and the 6th was being my deadline, put it that way. So I'll definitely endeavour to get them to you by the 3rd. And I'd like to think I would be completed by that date, but the 6th has always been in my mind. And we will continuously work this week and next week to get to that point where we can make the submission, if you put it that way.
Thank you very much, Mr. Pieske. We seem to be getting there.
Thank you, Mr. Chair. Thank you to your team.
Right, you're welcome. And you are excused from the proceedings
Thank you.
for today. Thank you. We now have Mr. Mposiopa.
He's coming in physically, and the committee just needs 5 minutes to set up.
5 minutes to set up the camera for a person who's coming to be here in person. We are adjourned for 5 minutes. The time now is 5 minutes past 2, 10, quarter past 2. Yeah. how do we pronounce your surname? Siopa or Siopa? Siopa. Okay, Mpo. Yeah, Mr. Siopa or Siopa. Mr. Siopa, I take it that we are on the same page as the purpose of today. But if I may summarize it, the purpose today is to get a sense from anyone about whom testimony has been given so far by players, by managers, by selectors, by coaches, anyone who has testified up to this point, who may have said things about you or about people associated with you, which you might feel it would be unfair to the process itself and to you if whatever it was said about you was not either challenged for its veracity or be commented upon, so that I could get a sense which is different from the one that I may get if the testimonies up to this point, which could have negative connotations about you, were not dealt with. So I created an opportunity for anyone who may have been mentioned to their detriment to be given an opportunity to engage those allegations. Now, you may or may not know that we last set on the 6th or 7th of August, a Friday, and we gave a fortnight, which we thought was enough time for those who had been mentioned to their detriment to respond, not only in writing, but to come to this platform and deal with such negative allegations. Now, during the course of last week in particular, I received a number of submissions or indications from people who had been mentioned who would like to engage the allegations made about them, that they need a little bit more time than I had given in order for them to be able to engage the allegations made against them. Now, I have an email from Leslie Twala, dated Saturday, the 21st of August, 2021, in which you purport to be requesting an extension in order for you to be confident that you will give me something worthwhile when you deal with any allegations that may have been made against you. or about you. So this is now an opportunity for you to tell me orally why you need an extension, if I have not summarized it, when you think you should be ready, by which I ask up to what date you need time in order for you to meet, to formally respond to the allegations made about you or against you. So this is your opportunity to tell me. Okay?
Good afternoon, Chair, and good afternoon to everybody.
Yes.
Chair, my name was mentioned when the team from Easterns came to do the Easterns Cricket Union.
Yes.
I was the CEO of Easterns Cricket Union.
Yes.
And there's still a legal matter that is still on the table in terms of from a labor practice side.
Yes.
So in terms of that, Mr. Neshte Gambia mentioned my name in terms of at the time there were certain irregularities which happened, which then I was the CEO at the time. And being given that, and my request was is there anything that he has submitted that I could be able to read, or is it hearsay? Because it's important at that time, if you were the head of administrative head, that is, it's only correct that I do this process justice by coming and accounting for my own actions at the time, and not just account verbally, but there should also be proof of the things that are purported to have happened in that time, because we can't just go on hearsay. Some of these things are beyond just what people say. As the head of administration, there were processes that were followed, and there were procedures which were followed, which are signed off on. So that was my request, to be able to do that, so that I can then be able to gather on my side any information that I need to be able to respond to that, and make sure that the Commission is aware of all the different aspects that they could have been overlooked on their side. That is why my request for the extension, Chair, because I believe there's a lot of information that the Commission is not aware of, that was not given, and I can be able to give a perspective on some of them, because being a CEO, you get to have access to the board as being a permanent invitee to the board, but you also get to have the operational side in terms of what happens. So that would be my request in terms of the time, and based on what I've gathered, I'm about 3 to 4 days away from having all my ducks in a row, Chair. So anytime
subject to what
So which date is that, Mr. Soma?
it would be the Friday. Next week Friday, I would be available. Anytime from next week Friday, I'd be available.
And to file the written submission?
I would be able to file the written submission by Thursday this week, because that's what I'd be able to do on my side.
Well, you must not shortchange yourself and then find that you are having to ask for further extension. Subject to what Mr. July will say, or any from his team, how does the 3rd of September accommodate you?
Well, the 3rd of September will also be fine on my side. It would have given me enough time to be able to do that. My only request or inquiry would be from a union perspective, as the people who spoke are currently active members within the union. Yes, I've received their testimony of what they've done. Is there any documentation which they have given that I can be able to peruse in terms of on my side? I've received the audio and the video. Those I've received. But in terms of what they submitted and the affidavits I've received, but is there any other thing that they've given in terms of documentation? I know from Tsuku's side, he had given numbers, so there was a whole lot of numbers that he was talking to in terms of payment, in terms of what the clubs were getting and all those details. I would request to be able to have access to that so that I can be able to respond accordingly.
If Mr. Sipo, you have been provided with affidavits and the transcript,
Yes.
and I can assure you those would have been the only documents in our possession.
Okay.
Because any other document would have been an annexure
Yes.
to
Okay.
an affidavit.
Okay. Then
So we don't have, if you received an affidavit which makes reference to an annexure,
yes.
maybe you can tell us that. We'll look for
No,
that annexure.
if that's the case, then I've got all the stuff.
You've got all the stuff.
I think that would be on Tate Tsuku's side. On Tate Nesh's side, there's a lot of accusation where there was no paperwork that then proves the accusations which were done, which I'll then be able to address them on my side and be able to do that. And then my second one would be from a commission side. Would you guys be able to get further information from the union? Should I be able to ask you to get it? I don't need to get it because I know it, but there may be some other details that you guys may have to request from the union itself.
At this stage, Mr. Sipo, we haven't received any further information from Easterns.
Okay.
Yes, so, but should we be in possession of like more information and we find that, you know, it might be relevant for the purposes of your submission, we'll definitely share it. The only other document we need to give you would be the annexure. I don't know if you would need it, where Mr. Tsuku had just given us an attachment detailing the budget allocation for the different clubs in the union.
Okay. If I may, please, Advocate, that would help. Okay. Yeah. Just to make sure that the numbers are spot on. A zero could mean something totally different. One less or one more, it's something very different. Yeah.
Okay, thank you. We'll provide it to you.
Right. So we are agreed on the date of the 3rd of September for you to make your submissions. If you can make them earlier, you know, you can do so. But failing that, you should make them not later than the 3rd, end of business on the 3rd of September 2021. Thank you.
Thank you very much.
You're free to. You have excused Mr. Siopo.
Thank you, Chair.
On my schedule, it appears that the next person who we will hear from is Mr. And he was going to talk about Mr. Cole.
Yes, and thereafter, South Africa.
Oh.
So it made, so we call.
are going to talk about CSA and you are going to talk about Mr. Louis Cole.
Yes, Chair. Thank you for giving me the opportunity to ask for extensions on behalf of both CSA management and separately on behalf of Mr. Cole. I know the program suggests that I will deal with Mr. Cole first, but given that CSA is requesting the longer extension, with your permission, Chair, if I may commence with requesting the extension for CSA first and provide you with the justification for that.
To what date?
So the date that I was looking for CSA's submission is the 13th of September, or 1 week from the date the last set of submissions are delivered. If anybody is given the opportunity to deliver a submission after the 6th of September. Mr. Chair, I agree with Mr. Abrams' submission of earlier today that no point would be served in trying to engage in an exercise of mudslinging. We are where we are, and I'm hoping that we can agree an appropriate and fair way forward. Unlike Mr. Becker, I'm not a commercial attorney. I am a disputes lawyer, but contrary to what Mr. Becker insinuated, Mr. Chair, you will know that as disputes lawyers, we fight when we have to, but we can be lovers as well. And I'm sure that there can be a good working relationship between us and Worksmans to sort out issues relating to a number of statements that we have not received as yet. My client is appreciative of the fact that Advocate Ntsebeza had, way back on the 22nd of July, requested the evidence leaders to make or to deliver notices to the implicated parties. That was then followed the very next day, Mr. Chair, by an email from you where you iterated that that was an important process. It needed to be urgently attended to, and that time was of the essence in the process. Unfortunately, it seems that there has been a delay in some of the transcripts reaching Worksmans, and in the process, Worksmans were only in a position to send us some of the transcripts on the 14th or the 15th of August. There's also been some submissions that we haven't received. I think we've listed about 31 people in the written submissions for the extension that we submitted on Friday. And but I see Worksmans in their response have undertaken to let us have a copy of all the written submissions or the affidavits that we requested. I've also confirmed that telephonically with Mr. July during the lunch break. Mr. Chair, then, as far as the question of why we need the extension, the transcripts alone at the moment exceed 3,600 pages. In addition to that, we're going to have to consider the affidavits and the written submissions. And if one has regard to the additional written submissions and affidavits that we still need to see, there is going to be a lot that we still need to work through in order to properly advise the management of CSA what it needs to deal with. Like Mr. Dupree this morning, I was also hoping that there were more express notices addressed to implicated parties about the allegations that implicated persons needed to deal with. But I accept that Worksmans has a different view on that particular issue, and I don't want to get bogged down into a debate about what's fair or what's not fair. I understand Worksman's view, and I'm inclined to try to facilitate the process. I've already had one discussion, for example, with Mr. July about an issue that I thought need not be dealt with, and Mr. July was adamant that he thought it was relevant and needed to be dealt with, and we've now, agreed that that's fine, and I'll communicate that to my client, and that will then be dealt with in the submissions if my client agrees. But what the failure to give notice about specific allegations results in is the fact that we now need to even more carefully work through the transcripts, work through the written submissions, and work through the affidavits in order to try to identify what we think are the relevant issues that need to be dealt with. I've already identified close to about 20 issues where I've asked my client to start collating information. Unfortunately, some of this relate to over 20 years ago, and therefore the collation of information exercise is a difficult and complex exercise. And the other difficulty is that a lot of the people that were the custodians of some of that information no longer work for CSA. So it's not such an easy exercise to be in a position to retrieve all that I have been asking for. I also believe, Mr. Chairman, that the rules of national justice will not be served if CSA is required to submit its submissions before you receive the last set of submissions from other parties in this process. And I know the argument that says, but some of those people may not implicate you. Even if that's the case, let me give the example of the allegations that have been made about government not doing enough to maintain facilities or to build new facilities. Now, if CSA's experience has been that government, in fact, has been doing a lot and there's been that good working relationship on that particular score, even though that evidence does not implicate CSA, I would expect CSA in those circumstances to come forward and say, it seems that some of the witnesses that gave evidence before these hearings do not have all the evidence before them. Here is the correct set of evidence. And that will make your job easier because you will then have all the relevant information before you in order to make the appropriate recommendations. Mr. Chair, on the question of prejudice, which always arises when one is requesting an extension, I don't believe that the process will be prejudiced. I believe that there are a number of other people that have already submitted submissions in the period between the last hearing and today, and some of those people hopefully can be heard this week or next week if necessary. I should then also point out that even though worksmen have adopted the position that they do not support our request, nor do they object to our request, their response to our request concludes with the following paragraph in paragraph 23. In light of what is stated above and in the spirit of the terms of reference, we do not think that it would be unreasonable to afford CSA an opportunity to respond to the allegations as it is in the public interest to do so. My reading of that, Chair, is that worksmen also recognize that we're not being unreasonable in requesting the extension until the 13th of September. Unless there are any further questions then regarding CSA submissions for an extension, Mr. Chair, I can go on to Mr. Cole unless you'd prefer to first rule on CSA's request for the extension.
I suggest you proceed to Mr. Cole.
Okay. Mr. Chair, on Mr. Cole, I should mention that he received a notice for the first time on the 13th of August 2021 when he had been sent an email from worksmen under cover of which affidavits of Mr. Mbelati, Mr. Tsotsobe, and Mr. Peterson were sent to him. We believe that it's also appropriate for him to get a copy of Mr. Tsolikile's written submissions. I know worksmen's contention in that regard is that Mr. Cole is not implicated by Mr. Tsolakile, so they don't agree that he needs Mr. Tsolakile's evidence. With due respect to the worksmen, we don't agree with that. because Mr. Tsolakile was one of the people implicated in match fixing or spot fixing, I should rather say, and was signed a sanction agreement with CSA. At the time, he had recruited one particular individual for spot fixing purposes and was also involved in a number of discussions with relevant parties who were also then charged and signed sanction agreements. So if he doesn't complain about the way the investigation was conducted and others do, it may very well be something that corroborates Mr. Cole's version that there was nothing untoward in regard to the investigation conducted by him and Mr. Becker. Also, I should draw to the Chair's attention that the 13 August email sent to Mr. Cole was sent in the evening after ordinary business hours. By that stage, Mr. Cole was already scheduled to give anti-corruption training to a number of players on Monday, Tuesday, and Wednesday of the next week. So the notice or the affidavits had been sent to him on the Friday evening. Monday, Tuesday, Wednesday, he was already booked to do the training, so we couldn't see him. I then started consulting with him, and I consulted with him for most of the day on the Thursday. I also then consulted with him on Saturday and spent most of yesterday. So I have worked all of the weekend starting to work on his submission. I'm already at paragraph 163 of his affidavit, but there's still a way to go because this was an 18-month investigation and I'm only in month 6. So that's the challenge we face with Mr. Cole, and I don't think it's realistic that his submissions will be ready before the 6th of September 2021. So we request an extension for him until the 6th of September 2021, and he'd be very happy then to come and give evidence or oral testimony during the week of 6th September 2021.
Yes. Mr. July? Anything in answer?
Yes. Mr. Chair, I will start where Mr. Masoji ended. Mr. Cole is currently an employee of Cricket South Africa. And we were labeled under the impression that the documents that we were sending to the acting CEO, those documents would, of course, at some point end up to the employees who are currently with CSA. So we forwarded all the documents that were required or were relevant for the purposes of Mr. Cole to respond to CSA. Now we know, and it is for that reason that on the 13th, subsequent to the meeting that we had on the 13th of August, that no, we need to serve Mr. Cole directly. And we did exactly that. And if then we are going to count from the 13th of August, it would make sense that Mr. Cole be given an opportunity to make his submissions. But like I said, our understanding has always been that all the employees or current employees of CSA would get the information from what is being submitted to CSA. What also complicated things, Mr. Chair, is that my colleague came to the picture very late.
Your colleague meaning? From Wexman, from
ENS.
ENS,
Yes,
okay.
yes.
Okay.
He came to the picture very late why I'm selling very late, because we had engagement. We had engagement with SACA. We had engagement with Mr. Becker right from the beginning of the hearing. And we had some understanding, although we may not have agreed on everything. But we have some understanding of what is going to happen. We may not have agreed on the issues of the date up front, but we had an understanding of how things were going to go. I only got a call from Mr. Musaji a week before the 13th. That would have been the week of the 6th, which ended on the 6th, where he told me that he is the representative of CSA, and which then meant that all this information that we have been sending to CSA, we would have sent it to him. And some of the issues that we are talking about them here, if he was in the picture or we knew about him representing CSA, maybe we should have been avoided. Maybe we could have given Mr. Cole's information separate to him and SACA separate to him. I don't know whether we were going to do that. But the difficulty that we had was the fact that when he came into the picture, he comes to the picture introducing himself as a representative of CSA, not of Mr. Cole. The representative of Mr. Cole is something that I heard it about 2 days ago. All along, even in the meeting of the 13th, Mr. Musaji never indicated to me that he's representing Mr. Cole. The person who sought to speak on behalf of Mr. Cole in that meeting was Mr. Becker. Because Mr. Becker raised the issue and said, but you guys, you have not served Mr. Cole. And then we said, but Mr. Cole has, the documents that relate to Mr. Cole have been sent to SACA. To CSA. Now that we are here, it's clear now there's CSA, there's Mr. Cole, and we are not going to fight about that issue. So the documents have been provided, and like I said, I think it's only fair that Mr. Cole be allowed an extension to file. But like I said, these issues could have been sorted out at a very early age. Have we been told that Mr. Musaji was the attorney, we could have had the meetings that we had even before the 13th of August. We are here now today because I had to call the meeting of the 13th of August when I realized that everybody was asking for an extension. And Mr. Musaji was not in the picture as far as we were concerned. Coming to the issue of CSA, yes, we admit that there could have been some affidavits which, in our view, we thought that they were not implicating CSA. And we could not have given those affidavits because we thought that they were not implicating. But of course, if the attitude of CSA is that everybody who comes and testifies here, implicating it or not, they want those statements. We have no issue with that. Those statements will be provided. But what, Mr. Chair, you need to know is the following. That CSA received the transcripts like what Maximans does. Every time the transcript comes from the subscribers, they go direct to CSA. CSA does not receive transcript from Waxmans. We receive the transcript together with CSA. And like I was saying, those transcripts were not sent to Mr. Musaji because he was not in the picture, as far as we are concerned. And he started by mentioning the date of the 22nd of July, which seeks to suggest that after the request for the details of the employees or former employees of CSA, we sat on that list and we did not send out the information to those. He may or he may not know that we did exactly that. We attached the list when we made the submissions reporting to the office of the OTO, that everybody who is listed was that list that was given to us. Of course, there are names of people whose details can't be found even by CSA. And those people, we could not send any information to them. But those whose details are contained in that document were furnished with information. So the list of the 22nd of July, for whatever reason why it is mentioned, we did what we were supposed to do with that list. We did send the information to those people who are in that list. We are not aware of any other list other than the list that was given to us by Ms. Ngale. And we did exactly that. Now, on we can debate about the 31 people who are listed in that document, but I don't think it would be a fruitful exercise to do that here, because we've got our own views about that 31 list. There's 31 people who are listed there. But to an extent that the information needs to be provided to Mr. Musaji, we will do so. He's correct to say we've got views about the notice, what constitutes a notice. What Mr. Musaji does not know, or he may know because that's what I raised during the meeting of the 13th of August, our proposal at the beginning, we would make summary of what the allegations are that are made against a person. And we did that. And at some stage, we started with Mr. Becker. We sent that information to Mr. Becker. And Mr. Becker came back to us. And he said, no, this is not going to work. We want the actual statements and the affidavit. Don't tell us where are the allegations being made to us. To us, it also made sense because it would seem like we want to channel people to a particular view, to the particular allegations. What then happens if what we said, and we did that with SACA, Mr. Chair. The problem with that approach, which we agreed with Mr. Becker, was that it makes you to concentrate on what you are being told, as if the other allegations, if we happen to miss them, are not important. And in any event, even if we were to channel you, it is the duty of any lawyer to advise its client, even if you are told. Reading the transcript, Mr. Musaji will have to do that, unfortunately, even if we were to come up with the notice that he has in mind. He is still required to read the transcript. And on that score, I agree that those transcripts are voluminous because he has to read them. And he has to see what is it being said and whether this requires a response or not. Of course, I agree with him that the principles of natural justice must be exercised. And it is not the intention of any person who is involved in this process to deprive anybody an opportunity to respond or to deal with the allegations that have been made against that person. In fact, we will be failing if we were to do that. We don't want people to respond to the allegations that are being made against them. Having said that, Mr. Chair, you will notice that SACA, long before you even said people who are alleged, whose allegations are made against them must be notified, SACA made its own submission. Because SACA, as we understand, they appreciated that this process is not about responding to allegations. SACA has views about what is happening in cricket South Africa before they hear the allegations. And it is not, they are not barred because they made submissions. they are not barred now from responding to the allegations. So it would have been much better and appreciated if everybody who has real interest of making sure that this process runs smoothly and there are stakeholders in this whole process to come and tell their story without responding to anybody. And it can't be a piecemeal approach. A piecemeal approach happens if you require people to respond to one person and go and respond to another person. So in any event, CSA should have made their own submissions and then respond to the allegations that are being made, which are specific allegations that are being made. And we like I said, there is no intention of depriving anybody of a right of natural justice. This process is bigger than all of us. This is the project owned by the people of South Africa. No one person owns this process. It is owned by the people of South Africa. So if there are issues, people must sort out their issues and make sure that the process goes smooth. It should not affect the process. And we have no intentions of depriving CSA. This is a CSA-initiated process. It is their process initiated by them, but it's owned by the people of South Africa. And therefore, we can't even try to say CSA must not have a say in this process. So if CSA is required now in light of what has happened up to now, they feel that they are not ready, and I think, Mr. Chair, they should be allowed. But we're saying the reason why we make the submissions that we make, we just want to set the record straight, because there are some insinuations that are being made in the statements about worksmen and the assistance that we give to this project. So it was just for that reason that we make these submissions.
You want to say anything in reply, Mr.?
Yes, Mr. Chair. Just on the question of the late notification about me representing Mr. Cole, as at the 13th of August, I didn't have the mandate yet to represent Mr. Cole. And it's only after Mr. Cole got the notification in the evening of the 13th of August that he then indicated that he needed lawyers, and he asked CSA to allow him to use CSA's lawyers. Yes, previously there was a lot of interaction between Mr. Becker and Mr. Cole, but I suspect that Mr. Becker correctly advised him that given that Mr. Becker is going to be a witness in his own right about the match-fixing allegations, it's better for Mr. Cole to be separately represented on that particular score. On the question of me mentioning the 22nd and the 23rd of July, that wasn't designed, Mr. July, to suggest that worksmen have not done what they were supposed to do. It was simply designed to indicate to the chair and his junior that my clients appreciate the fact that they are complying by the terms of reference, and they were, from early on in the process, concerned about the question of notice to the implicated parties. On the question of the expectation of CSA to give notice to its employees, with all due respect to worksmen, I don't think that that is a reasonable expectation, and I say that for a number of reasons. Firstly, 5.4 of the terms of reference provides that the Ombudsman shall handle matters before him in accordance with the rules of natural justice and the Constitution, and it goes on to say if an allegation is made against any person or an organization in an affidavit, such a person or organization shall be notified and will be given an opportunity to respond to the said allegation within a reasonable period of time. We read that as placing the obligation on the Secretariat to give all implicated person's notice. The other thing we need to be alive to as well is paragraphs 6.2 and 6.3 of the terms of reference. 6.2 says no person may interfere with how the Ombudsman conducts his investigations and hearings and reaches his conclusions and recommendations. I didn't want my client to be accused of interfering by my client sending notices to various people saying you're being implicated and you need to go and submit or make submissions. Over and above that, 6.3 places the responsibility on CSA to provide logistical and administrative support to the Ombudsman to perform his functions, including but not limited to the provisions of venues, transcription services, and so on. What's interesting is that it doesn't go on to also indicate that my client was required to provide notice to implicated parties. Over and above that, we know, for example, through David Becker, that notices were sent to David Becker and to Graham Smith at the time or the time period for which David Becker is implicated relates to the time period when he was an agent of Cricket South Africa. Over and above that, Graham Smith is currently an employee of Cricket South Africa. And then there was a whole list of email addresses that were requested, which included the names of current employees of CSA. So under those circumstances, I think CSA could legitimately expect that the notices were going to be sent directly through to the implicated parties by the Secretariat. But let's not cry over spilt milk. We are where we are. And I think at the end of the day, let's do the best we can in the circumstances and give people a reasonable time to deliver their submissions, but at the same time be cognizant about the fact that the Ombudsman also has to receive the submissions within a reasonable period of time so that he can perform his functions. I should also just give you another example of why, if people are not given notice of the actual allegation and simply the transcripts or the affidavits, it becomes quite dangerous ground. And the example that was pointed out today by Advocate Dumisa of Graham Smith's remuneration of 5.4 million rand, Advocate Dumisa suggested that that was a commercial matter that did not require a response from Professor Fall. Now, it may not, unfortunately, be as straightforward as that, and I would have to go back to the transcripts. But if the transcripts suggest that there was the increase from 4 million to 5.4 million simply because Graham Smith was white and it wouldn't have happened with a black person, then it's not simply the increase that is an issue. There's also linked to that particular issue the question of race having influenced the increase in question. So some of these issues become very, very tricky issues, and that's why I was very appreciative of the interchange I had with Mr. July about whether or not it was necessary for CSA to deal with the match fixing allegations or whether that was going to be dealt with by other people. On the question of the transcripts, I have received from my client the transcripts, and I haven't complained about not receiving the transcripts. My concern is I don't have all of the written submissions and the affidavits, and I'm made to understand that some of what is contained in the oral testimony wasn't identical to what's contained in the written submissions, and it's therefore important that we have both. But Worksmans, as I understand it, have undertaken now to provide us with that, and hopefully we don't need to dwell on that particular issue. Also, I think the criticism that CSA should have made a submission without first waiting to hear what it needs to respond to is an unfair criticism. At the end of the day, this is a process in terms of which recommendations are going to be made by the board of CSA, and CSA would then have to take those recommendations into account and hopefully implement those recommendations. Now, in circumstances where people have come along and given oral testimony, if CSA has no basis to dispute their testimony or doesn't have information which presents another picture, then I don't believe that it was incumbent on CSA to make a submission for the sake of doing so. That would have just wasted the time of the submission, of the chairperson and his team. And for me, it's only important for CSA management to come and make a submission if they have information available to them which presents a different side of the story. Because then it's important that that information is placed before the chairperson, and the chairperson takes that into account when making his recommendations. Thank you, Mr. Chairperson.
Mr. Musaji, I just had a question, just for the purposes of clarity. Is CSA able to respond to the allegations leveled against CSA without, the detailed allegations from the evidence leaders? Because my understanding from Advocate Dupree was that they are not in a position to respond at all. They need adequate notice. So I just want to understand, is that CSA's position as well? Or are you able to proceed with a response without that particularity you're speaking of?
Advocate Nwele, if I had my preference, I would have a list of just the themes, even if you can't give me, long, this is exactly the questions you need to respond to. I would request the themes that you wanted us to concentrate on, because unfortunately there's a lot that has come before these hearings. And I accept that the chairperson has a challenging task to work out what part of that relates to the terms of reference and what falls outside the terms of reference. So I would prefer to have themes, but if the chairperson rules that, no, please do the best you can do in the circumstances, I don't want to hold up the process. And that's exactly what I will do, is I will try to work out what I think they need to respond to. But the one danger there is, if I've read things incorrectly, you may not end up with a submission on an important issue that the chairperson believes is important, but I did not regard as important or falling within the terms of reference.
Yes, Mr.
If I can, I think I get what Mr. Musaji is talking about. We can do that. I think that's what we initially wanted to do. And when you talk about the theme, I think that's the idea that we had even right from the beginning. And I fully agree. I fully agree with that.
Okay. Yes. I'll say two things. The one is a question. So what is the date you would ideally want to propose should be the date by which you make your rebuttal submissions?
Ideally, we'd like until Monday, the 13th of September.
Oh, because you are representing two entities.
Yes. one person in one entity.
One person in one, yeah. Now, Ms. Abram is intervening from a privileged position of being here. when it is now, are you asking for a separate date for Louis Cole and a separate date for CSA?
Yes, for Mr. Cole, I am hoping to get you his submissions by the week of by Monday, the 6th of September, so you can still hear his evidence during that week of the 6th of September. So ideally, the only evidence that will be left for the last week will be CSA's evidence.
And that you want an extension till the 13th?
Yes.
September. Yeah, you find me at a time when I'm a bit generous. Well, I think you should get those orders.
Thank you, Mr. Chair.
I have been confining others to the 3rd of September because I wanted to use the weekend. But as I say, you find me at a time when I appreciate that you are trying the best you can to find common ground with Mr. July, and my appreciation of that endeavor leads me to say keep on liaising with the Secretariat about any detail you may not have mentioned here. Because, I mean, what is important is that we should reasonably get to a stage where we all say, well, it's not a perfect process. It was never going to be, because it's quite a contested arena that is being addressed. But we are trying the best we can to, to find justice in the best way we know how, where there are contested views that must be conveyed to me for my decision in a manner that is not going to be prejudicial to anybody, other than that it is a matter which has no explanation if it does appear to be prejudicing any of the people about whom testimony has been given, or any of the entities about which testimony has been given. So I grant you to let me have, by the 6th of September, any submissions you want to make about Mr. Cole in Dubatam, and then until the 13th of September, in relation to all allegations about CSA. And that
Thank you, Mr. Chair. Indulgences are appreciated. Mr. Chair, can I raise just one other issue on the question of the notices, if I may?
Yeah.
And that is that there has been some engagement between Worksmans and myself about whether or not it's necessary for Worksmans to give notice to former directors or former CEOs of CSA regarding certain evidence that implicates them. Now, I understand Worksman's submission to be that in relation to issues that relate to the previous board, they believe that this is still the same entity, and therefore the current board needs to answer for the previous board. And, I will take an instruction on that. But I'm not focusing on that now, because to the extent that those are issues that the board's discussed, and that at worst for me, I would be able to go back to ask for minutes of meetings to check what those minutes say, and that might give me an objective basis to tell the people that are currently serving on the board that this is what your minutes say, and therefore it appears from the minutes that this is what transpired. But it also seems to me, listening or reading some of the transcripts, that there was evidence that implicated, for example, Mr. Nenzani, Mr. Williams, Beresford Williams, Marius Kuman, a few of the former CEOs. And as far as that is concerned, I think it's important for Worksmans to give copies of the affidavits and the transcripts, and to invite those former board members or former CEOs to make submissions. My concern is if I did it, or even if the current acting CEO of CSA did it, it might not have the desired impact. People may feel that they've moved on and they therefore want nothing to do anymore with CSA's affairs. But I think if it comes from the Secretariat of the Ombud, it will carry more weight and there will be an indication that if the Ombudsman will appreciate their input so that he can make a decision based on all relevant facts, I think that will really be useful. So all I ask for, Mr. Chairperson, is a plea to Worksmans to give notice to those former board members or former CEOs that were implicated in their personal capacities.
Mr. July?
Mr. Musaji, I think we are on the same page. We are on the same page. And I've been under the impression, after we spoke, that those members who have been specifically mentioned will receive the notices. Where we were differing is where we were talking about a board as a unit. We then said the CSA should respond, where they say board members did not do anything. So, but where specific allegations are made against a specific member, I agree with you. We need, and I've been under the impression that we gave that to Mr. Ntsebeza, for instance. Yeah. If it has not been done, we will definitely do it.
Yeah, the list of notified parties, which may not be an updated list, but the list that we received this morning from your office suggested that Mr. Nenzani, Mr. Williams, Mr. Skuman, and various former CEOs weren't given notice of the allegations. So I think you might just want to check with that and come back to us.
That's fine.
Okay. As I said, Chairman, I like the fact that I'm able to hear from the parties that we are on the same page, remain on the same page, and therefore the channels of communication between Worksmans and ENS in regard to these parties, specifically for these two affected individual and entity, I think will cause you to remain on that same page in regard to all of the issues that have been debated by all of us this afternoon. But the dates remain 6th of September and the 13th of September.
Thank you.
And subject to that undertaking by both of you, respectively, I think I've heard you, and I have no problem with the dates that have been suggested and put, and I so order. The dates are the 6th of September for Louis Cole, the 13th of September for CSA. What happens to my timeline is anybody's business, but that is that is where we are at the moment. The next item was going to be Worksmans. I do not think that I need to hear them. I've heard them too much today. Sufficient that every presentation by any presenter, I heard Worksmans. So I don't need to hear them again. I think that brings us to the end, and Mr. Musaji, thank you very much for your helpful participation. We are adjourning now, unless there's something that you wanted to. Oh, it looks like, yeah. We are adjourned for the day. We can leave our, yes.
Thanks.